And first, I want to say good afternoon to everyone and Happy New Year. We made it to a new year with all these things happening. It's great that we can all be together, even if in this virtual platform, to get this work done. So good to see you all. I think the first thing I should do is a roll call to make sure everyone is recognized who's on this meeting. So I'll start with Justice Ecker. If you could just say here, that'd be great.
Here.
Judge Goodrow.
Here.
Judge Youngblood. I know you're here.
Here, yeah.
Judge Morgan.
Here.
Judge Prescott.
Here.
I don't think Judge Sheldon showed up, but if he did, Judge Sheldon. Okay, Attorney Edelman. He couldn't make it, that's right. Attorney Brookman.
Here.
And Attorney Costello.
Here.
Attorney Gaylor.
Here.
Attorney Goulash. No, Attorney Goulash. Okay. Attorney Massacott.
Here.
And Attorney Steigelfast.
Here.
Okay.
And
I just
Professor
saw-
Simon Kerr is also here.
Okay, Professor Simon Kerr.
I just saw MS show up. I don't know. Is that our?
Yes. Judge
Sheldon?
Sheldon, is that you?
Couldn't be if he's that quiet.
Maybe he's figuring out the mute button. That happens. All right. Hopefully that's you. It does. Yeah, I do see Mike Sheldon. So if that's you, Judge Sheldon, just let us know when you work out the mute button. Okay. So we'll get going, and the first thing I want to do is ask if everyone's had an opportunity to review the minutes from our last meeting, and ask if there are any corrections or changes that need to be made. If not, then by consent, I will say that those minutes are approved, hearing no objection and no corrections. So with that, having approved those minutes, I think we could take up the business that we left undone from the last meeting, and specifically on section 9-3A, there was a revision that was requested by Judge Sheldon. And I think we've made that revision, I think certainly to his satisfaction, but want to open it up first to Justice Ecker to see if there's anything else the committee wants to add to the change that was made. If not, then we could take care of all the sections we dealt with last time and this new section.
I have nothing to add myself. I don't know if any of the other members of the working group have anything to add. I appreciate, we got through everything last meeting, and Judge Sheldon, with his usual eagle eye, caught, an omission, or what some would consider an omission anyway, that we corrected by adding this new subsection 1 to 9-3A subsection A1. The affiant is the duly authorized custodian of the records or another qualified witness who has and is acting with authority to make the certification. And that I think that does the job. So with that, I'll I'll leave it to others if anyone else has a comment, but I don't have anything to add at this point.
Does anyone else from the working group anyway have anything they want to add? I know that we've had some conversations and went over this language, and it was acceptable. Okay. How about the larger committee? Has everyone had an opportunity to review the new language in 9-3A1? And if so, any thoughts, suggestions, or anything you would like to share about that? Okay. Seeing none, then with respect to the changes that we are proposing to the code, dealing with section 1-1, 1-3, and the new provision 9-3A. Is there agreement amongst us that these are the provisions and the changes that we are going to recommend to the Supreme Court?
Yes.
I think so.
Okay. All right, thank you. I think so those changes as they appear in the documents that you have will be the changes we recommend to the Supreme Court. We will put a pamphlet together for the court and get it over to the Supreme Court for them to review and vote on. With respect, so that takes care of the changes we were recommending to the code with respect to those provisions. What's left is the Public Act, which has now been codified, and what we want to do with that. I think our last conversation, one of the issues that came up was whether we were going to take all of the sections and just kind of wholesale make that a section in the code. One other sub issue was whether it was going to be a new 4-11B, or where its placement would be in the code. So those were two of the issues that came up. One, whether we're going to take it all or just take pieces of the now statute and put it in the code, and then where in the code it should appear. Does anyone have any thoughts on at least the first part? Should we take it all or just portions of the statute to codify in the code?
Yeah, I have some thoughts on that.
Okay.
There are 3 places in the code where we've just wholesale.
I'm sorry to interrupt, but could you just identify yourself, because everyone may not be able to see you pop up?
Sorry, Joe Bruckman.
Okay.
So there are 3 sections of the code where the committee has just basically cut and paste a statute and stuck it in there wholesale. And one, of course, is 411, which is the admissibility of evidence of sexual conduct in criminal cases. And then there's 8.4 business records, and then 8.10, the tender years exception. And I think there are 2 possible problems when we just wholesale adopt the language of the legislature. First of all, there could be inconsistencies between the statutes, and here, no matter where we put this, this would sort of be a sister rule to 411 regarding criminal cases. Well, there's some inconsistency. Just an example, in 1916, the Public Act we're talking about, the term victim includes an alleged victim. Section 411 just uses the word victim. I mean, it's not a big deal, but we'd like to have consistency, I think, in what we do. And secondly, there can be inconsistencies between the statutory language and other provisions of the code. And here I'm looking at 1-2, the purpose and construction of the code. The purpose is clearly to create rules of evidence, or to codify the rules of evidence as developed in the case law. But in the commentary to that section of 1-2, it says, unlike the federal rules of evidence, which govern both the admissibility of evidence at trial and issues concerning the court's role in administering and controlling the trial process, the code was developed with the intention that it would address issues concerning the admissibility of evidence and competency of witnesses, leaving trial management issues to common law, the practice book, and the discretion of the court. So what we have in the Public Act, subsection D seems to really go into a little bit of the minutia of the procedure to be used, which I think is inconsistent with the commentary to 1-2. Now, while it might be helpful to have everything in one place, you have the rule, you have the procedure. I think we just have to make a decision whether we want to abide by or 1-2 or change it to include the procedure. I think as things stand now, the procedure should not be part of the rule. And in subsection D, the legislature is really micromanaging the court procedure, giving deadlines as to when a motion has to be filed. And of course, if the Superior Court, the Supreme Court acquiesce in what the court is doing, then it's fine. But the General Assembly does not have the power to, create court rules. Again, the court can acquiesce in them, but the question still is, do you want a procedure section within the evidence rule itself? So I think that's the issue I had last time, and I still have it.
All right. Thank you. Anyone comment on that or feel differently? Well, let me just ask, Attorney Bruckman, would it just be subsection D that, suppose we didn't adopt subsection D? Are there other sections that you disagree with putting into the code?
Well, subsection E has a little bit of procedure, but that's already in the code for 411, requiring in-camera review. So again, for consistency and whether it belongs there, but it's certainly less deep into the procedure than what we have in subsection D.
Right. Any other thoughts or disagreements with that?
This is Karen Goodrow. Joe, hi Joe. I haven't seen you since the last meeting. Is there an advantage? I'm just playing devil's advocate for sake of clarity to have the whole thing in there, or do you think that's outweighed by your concerns you've raised?
Well, when the code was originally drafted, the idea was to have all the rules in one place, all right, all the rules of evidence. It's certainly helpful to have the procedure right there too, but the question is, does that conflict with, the 1-2 commentary? And I think it does.
How did the committee as a group resolve that conflict on the other sections that you mentioned? Or is that
funny
to even think about at this point?
Like the 10 years exception, the committee was actually working on that when it came down from the legislature. I guess someone on the committee had word that it was coming. Okay. So it was like no choice. We just said, well, here it is. So I don't think we gave a lot of thought to, like the Clementi problem of whether the legislature is making rules for the court, or even the inconsistency between, what was passed for 411, the statute that was passed was like 37 years difference from what we have in Public Act 1916. And so, you can't expect there always to be consistent language, and that's why we have victim and alleged victim, that would have to be sort of ironed out, I think.
If I may, Justice
Sure.
Mullins. So I guess two questions, and they're both questions. Just one is whether, I agree wholeheartedly with Attorney Bruckman, and glad he pointed out, the procedural point the fact that there's a separation of powers issue sort of lurking. The question, I suppose, is whether this procedure works from a judicial administration point of view, or at least that's one question. It's and I guess so. My issue there is just whether that's something that we should consider, or whether it should go to the Rules Committee for them just to take it up. It doesn't seem to me, I mean, it makes some sense to have a rule on procedure about how to administer this particular rule of evidence. Whether we should take that up or the Rules Committee should do it. Seems like somebody should do it and look at it from the perspective of judicial administration. The other question I had, I'll just throw them both out at the same time, and I should know the answer to this. I should know the answer to both of these, but I don't. Is whether there are other similar statutory evidentiary rules that we've chosen not to incorporate into the rules of evidence, and that may help us decide whether this is one we should or shouldn't incorporate.
There are a couple hands up. Lori, you may have a clarifying point on something that Justice Eckert just mentioned. Do you?
Yes, Justice Mullins, we were speaking about this yesterday in 4-11. If you look at the first paragraph of the commentary, sort of midway down, in 2015, General Statutes 5486F was amended and added procedural subsections B through D. And the commentary states that because B through D addressed more procedural matters, the committee made the choice to only quote subsection A in the rule. So that's in 4-11, first paragraph of the commentary.
Yeah. Judge Prescott, did you want to say something?
So to respond to your comment, Justice Eckert, there are of course many privileges that are codified in statute, rules of exclusion that we have not incorporated into the code. And I could probably come up with a few others outside the area of privileges where there are evidentiary rules in the statutes, rape shield being another one where we just have not kind of uniformly adopted or parroted the language of the statute. So the danger to me first of all, I agree with Attorney Bruckman that we should keep out the procedure. That's not in my view, what the code's for. The danger in just kind of quoting the statute, of course, is when the statute gets amended, it requires us to go back and make similar changes if we're trying to keep trying to ensure that there are no differences between the rule and the statute. On the other hand, the positive side about doing that is having the practice, the evidence code provision and the statute be identical, is it eliminates kinds of concerns about who has the authority to make these rules. So it's a little bit of a two-edged sword. I guess I come down on keeping the procedure out and perhaps copying the statute, but being attuned to the need to amend it if the statute does change.
Sure, Judge Youngblood.
Thank you. I just really an observation or a comment that my recollection is that 411 change that we made was hashed out in the subcommittee initially, and then a recommendation was made to the whole committee, as we often do on this committee with proposed changes. So not to delay things at all, and maybe we don't need to go that route, but I just throw out the thought that maybe this is something that we might want to have a subcommittee look at, which could then make if there was agreement there, that could make a recommendation to the committee. I just just wanted to throw that out as a thought.
Okay, thank you. Judge Morgan?
As I'm reviewing 4-11, where we did the wholesale incorporation of the provisions of the statute, there is some procedural stuff in the middle there that hasn't been sort of separated by a subsection. About 2/3 of the way down, it talks about in-camera hearing on a motion to offer evidence, etc. So while I agree that the procedural stuff, I don't think the procedural stuff, such as the in-camera review, should be included in the rule. But if we're not going to include it for the new statute, maybe we want to take a look at redoing what's already in 411 and excluding the procedural portions that already exist in 411. I think we just need to treat them the same way.
This is Judge Sheldon. I agree with Judge Youngblood's suggestion that this would be appropriate. There's too many different angles at which this should be looked at. The Rules Committee certainly is one of them. What's interesting is that, there was a practice at least years ago when I was on the Rules Committee of meeting with legislative leaders every year, once or twice a year. In fact, Justice McDonald was the person we would meet with. And precisely the purpose of it was to make sure that there was some parallelism between the development of rules that might have procedural components and work that was ongoing on the Rules Committee itself. Clearly, there is the power, as Joe was saying, to adopt and to agree to or acquiesce in what the legislature passes. But I think the Clementi issue, even though nobody really likes to go there, has never been put to bed. It seems to me that we have to be careful about it. And if we're going to do it, I agree, we should measure twice, cut once, and treat things similarly. So the way to do that, I think, is again, maybe a combination of what Judge Morgan said, Judge Youngblood said, have a small committee and have them relook at the entire rule to determine if we're treating things in parallel fashion. And I agree with Judge Prescott. I think that generally speaking, procedure doesn't belong in the rule. However, I think we could make some note in the comments which suggests that there is a procedure that's mentioned in the rule. And we might even go so far as to say the court will resolve those issues as they arise in the ordinary course. I don't know that we need to do that, maybe just thumbing your nose at the legislature, but on the other hand, as a practical matter, I think that's what the Constitution requires.
Thanks, Judge Sheldon. Is that a hand, Justice Ecker, or from before?
No, I raised it again. I tend to do that. It's good there's only one icon up there, with one hand, because otherwise I might raise two. But thank you, and I'll try to keep it short. But the other thing that occurs to me is that when we do adopt the rule on our own, it stamps it with the judicial branches, whatever, imprimatur. It says this is a good rule. I think that's implicit. Maybe it's just well, if the legislature says so, we'll say so too. But there could be an implicit sort of endorsement of the rule, and not only that, but of the language in the rule. And as I read this language without suggesting one way or another, I don't want to say too much, but a committee might want to look at that. There's certainly, it's not obvious to me that the meaning of this rule is completely clear and translucent, transparent, and obvious in meaning, or that all of the ramifications have been considered. I don't mean that out of any disrespect to the legislature that enacted it, but it's just about taking an independent look. I wouldn't want to pass a different rule with different language. That would be a recipe for disaster, probably. But it makes some sense to me that the committee as Judge Youngblood proposed, that's one of the things that it takes a look at. Just is, what does this thing say and what does it mean? It's pretty broadly worded.
I agree. Is there? I think I agree with the idea to have a sort of smaller working group take a closer look and see, whether we should adopt it wholesale. If not, why not? Look at the language. Many of the things that have already been said. I don't want to cut conversation short if there are other things people want to say, but if we are going to have a small working group, we're going to be having this conversation again very soon. So that just leaves who wants to volunteer to be in the working group.
I'm happy to volunteer, but I might be learning more than contributing.
I think that's A-OK. Is that you, Judge Goodrow?
Oh, yes.
Yeah, I think that's A-OK. I see a hand. Is that a hand for a question or a hand to join the working group?
That's a hand to volunteer. Certainly, I'd be happy to do it. I was on the subcommittee that dealt with the 411 also, but I mean, I if you don't need me, fine. But if you need me, I'm happy to do it.
That's great. You'll bring some institutional knowledge for Judge Goodrow. Maybe one more person. I think the 3-person small working group should be fine for this issue. Attorney Brookman, you're not chomping at the bit, I see.
Well, I was going to, but I saw Judge Sheldon's hand go up.
I don't
Joe.
see. I don't see.
You should have Joe. He's the one who proposed it. I'm happy to help. I think I have more time on my hands than any of the rest of you. So that's one reason.
It doesn't have to be a 3-person. It could be a 4-person group. There's no rule against it. So you both can win.
Yeah. I'm happy to do it.
That Great. Sounds like a Jets fan to me.
Especially with Mike.
Great. All right. So Judge Goodrow, Judge Sheldon, Judge Youngblood, and Attorney Brookman. I'll be in touch with you guys to see when we can schedule another meeting, but I do want to give you guys time to look into it, and so we'll be in touch. I think for today's business, there's not much. There's nothing left. I think we agreed on the 1-1, 1-3, and the 9-3A new language. We have a working group set up to take a closer look at the new Public Act, which is codified now, 411, and see what we are going to do with that and how. So I don't believe there is anything else. Let me just check the agenda. If you give me 1 second. If you just bear with me 1 second.
Nothing else on the agenda, if that's what you're looking for, Justice Mullins.
I am. I just wanted to be certain, but thank you, Justice Ecker. I don't think there's anything else. Unless there's anything else any of you want to talk about, I will entertain a motion to adjourn.
So moved.
Seconded.
Morgan.
Is that Judge Morgan? I didn't hear you.
Yes, second.
Great. Any discussion? Seeing none. Great to see you all.
Good to see everybody.
Happy New Year, and I'll be in touch with the working group and see when we can schedule another meeting. And everyone take care.
Take care. Thank you, everyone.